Hi guys, it's Kathy. I hope you're doing well. Yes, we fucking missed Chinny's birthday. Yes, we knew about it. Yes, we did. I'm so sorry. That's the worst part about yesterday. I was thinking about that at work today. Mm. We missed Chinny's birthday. Mm. Which just made me more angry at everybody else. I was so angry at my family because we missed Chinny's birthday that I was at work yesterday throwing cups, throwing spoons into the bin. Chinny, I hope your birthday was great. Happy birthday. Happy birthday, Chinny. Man, we should guess how old Chinny is. You already fed your cats? Oh, you might. You may. Gotcha. Chinny's birthday. 29 is a good guess, Zach. I like that guess. Stealing it. I said 29. So, we haven't been to Jersey for a while. Bobby. So we're going to go back to Jersey today, but not Nakama. I didn't get Nakama. He wasn't on. So I went with detention hearings. I don't know the name of the judge. I don't even know where. Ocean? Is there an Ocean County, New Jersey? Maybe we'll find out. Maybe we'll all find out together. I'm just trying to see if it's listed on here anywhere. Oh my gosh, it might be Ocean. Because look at the top right. Is that an OCN? I think it is. Alright, here we go. New Jersey.
S1, the certification in support of pretrial detention and would rely upon the grounds as set forth therein. With regards to probable cause, the state relies on S3, the complaint, specifically the affidavit of probable cause, and S4, the Appendix A. The state will also submit and rely upon S2, the PSA, and S5, the defendant's CCH.
That prosecutor looks 17 years old.
All right, thank you. The court has reviewed S1, the certification, the E-courts. The court will find the motion for pretrial detention has been properly filed in this matter. Regarding the eligibility for detention.
Oh my God. Guys. We missed Chinny's birthday. And then we opened today talking for 3 minutes, 34 seconds about Chinny's birthday. And Chinny's Wi-Fi crashed out. Chinny missed all of it. Chinny, happy birthday. I'm sorry we weren't here for you yesterday. Happy birthday. Zach, thank you so much.
Some of the charges involve a first and second degree charges. Also involves domestic violence. It's also alleged there's a serious risk that defendant will not appear in court as required. She'll pose a danger to another person or the community, and or the defendant will obstruct or attempt to obstruct justice.
It's this person right here in the on the right hand side in the middle square.
Or threaten, injure.
Oh, wrong one. Sorry, I thought that was muted.
Or juror eligibility has been established, and the state's in agreement with the eligibility as set forth in S1. Ms. Rojas had indicated she heard and understood the detention rights, which I read, so I'm going to proceed with the issue of probable cause. However, her attorney did indicate for purposes of this detention hearing only, she'll stipulate to probable cause, and this court has reviewed the state's items in evidence regarding probable cause, underscoring the complaint and also the comprehensive Appendix A. The court will find that probable cause has been established for purposes of this detention hearing. However, there's still a rebuttable presumption against detention. I'm going to hear at this time the reasons why The state is seeking detention. Then I'll hear reasons for her release by her attorney. Prosecutor, you can proceed.
Thank you, Your Honor. On October 24th, 2025,
I go to Ocean City every year. Well, I don't. I did. Growing up, we went to Ocean City every single year. And then, so there are two sides to my family. There are people who don't break the law and then don't lie every freaking sentence. And then there was the other side who cannot get through one sentence without lying. So every year growing up, my mom, my dad, and the three children would go to Ocean City and camp. So we would go to Eagle's Nest campground every year forever. And then we switched to Frontier Town. So I don't know, I'm guessing 15 years ago, maybe even more, I had enough with the one side of the family. I just straight up turned around and walked away. No communication, no nothing. But there's cousins, and so even though I was not directly communicating with either of my sisters or anything like that, I still had three kids, and they all have kids, and the cousins talk, and so there's still connections. I can't just I'm almost able to, because their kids are older, my kids are older, and Patty's kids don't even talk to her. Well, one does. It's complicated. Anyway, they don't talk to her, so my connections to that side of the family is way lower. It's still there, because they're still cousins, but it's super low right now, except when it's not. So on my side of the family, the normal side, job. Okay, I know I just did get fired recently and I got another job. But job, my car has a valid inspection sticker on it. It's not a fake one. So that's different. Well, for my side, I am the person everybody kind of leans on. And I'm saying this because I know every single person in here understands exactly what I'm saying. Whenever there's the slightest that it's me, they call, they text, they come into my bedroom. It's just me. So when there's little dramas, I'm able to handle it. It's every day. It's all the time. I handle these little dramas. And then bigger dramas that happen solely land on me. Like nobody has any freaking clue what to do. So, yep, Nan, yep. So yeah, it doesn't matter what time of the day or night or what's going on, or even if it's a holiday, especially holidays, Halloween, drunk people, drama. Absolutely, Chinny. So yeah, that's why I missed your birthday. I wasn't even home that night. I handed out candy. It was great. I was relaxing. It was great. And then boom, just like that, out the door. Out the door I went. Had to go save a kid from a mom. Make sure no one goes to jail. That's my biggest role, is just to make sure no one goes to jail. I physically have picked many of my family up and thrown them into a house to make sure they do not go to jail that night. They can go to jail tomorrow when they're sober, but yeah, I got home. It's always the middle of the night. Like Why don't they just go to bed? And that's all I keep asking. Why aren't you asleep? Why don't you just go to sleep? And you know why? Because you cannot sleep on meth. Like, you just can't, I think. You just can't fall asleep. So they're like up and they're like causing crap, you know? So I get home yesterday. I think it was like 7 a.m. It was crazy. It was an ungodly crazy hour. And I remember opening Discord. I remember I was talking on Discord to you guys, and my eyes just, I didn't even, the phone is still in my lap, not in my hands anymore, when I suddenly woke up because the alarm went off, and then I had to go to work. And Zach said happy Catterday. That was yesterday. Oh my gosh, no way, Zach, no way. Martha is the only thing that got me through after I got off my double last night. Boom. 2 patches. Oh man, my whole body hurt after that double. It was so bad. It was such a bad double. The trash can. So I rolled my trash can, this big red trash can, out to the dumpster. And I can't get the bag out. I'm trying so hard. It's over full. So I'm lifting, I'm pulling, and I can't. I think it was the strength in my hands. I even turn around and like squat down, try to reach back over my head and stand up. That bag will not come out. I was so mad. I was so mad. Finally, I picked the entire trash can up, and the stupid dumpster is over my head. I picked this entire, just the whole trash can up, throw it into the dumpster, and then the wheels are sticking up, and then I grabbed the wheels and I was able to pull it back out. But that trash bag will forever haunt me. Like, that's a core memory now. The day I had to get that trash bag into the dumpster, couldn't do it. I just couldn't. I don't want to do Saturdays again. I don't want to hear anything about family for 17 more years. I just don't. Oh my God, that is such a good idea. I hate you. I hate you. Oh my God, that's such a good idea. I can't believe that idea. The thing is, there's a lot of liquid in the bag. But if I'm holding the top closed, I can't, Zach. I'm 4'2". I can't reach my arms down in there. It goes up to my shoulders. Like, I just can't. But I can tip it over and pull it out sideways. That I can do. That's a great idea. Oh, there is a rock I can stand on, Zach, back there. I just, slide my arm down in between that bag. Block it out. That's exactly what I'm trying to do today. Just reset. I'm sure I have weeks at least of calm now. You know how it gets all drama, and then for weeks it's like chill. That's what I'm on right now. Just, well, you know what though, Chinny? If I do that, I would have to deadlift the trash bag from the ground. That might be really hard. No, I'm just throwing the whole trash can in. The trash can is easier because the bag, you have to grab onto this plastic bag without ripping it. And with the trash can, I can just it's sturdy. It's way sturdy. So I can just throw it in there. I think, I don't know. I will try it though. I will try anything to make it easier. What I'm going to try instead is at intermission, take the trash out. Just take the trash out at intermission. And then by the end, I only have half a trash bag to throw out. Might drip on me? Yeah, they do that all the time. Everything drips on me. As a server. I get so dirty. You don't even know how dirty your server is, guys. But I am like you can see how horrible my hands are from washing my hands constantly. I have constant ways to clean my hands off in different areas. I have regular just washcloths, all wet washcloths in this nook, in this tunnel, and then the sink. So yeah, we are constantly washing ew off our hands. No, I do not wear a hair restraint. I put it in a ponytail or a bun or braids. I do something with my hair that gets it behind my head. It's always something a little different. And then, I have my serve safe manager. That was fun. So this other server that I worked with yesterday, she came in and she made $800 the day before. Tipper. You tipper. You tip that server. That's what you do with that. Server I worked with yesterday morning said that she was a private bartender at a wedding the day before and made $800. I love my manager to death. Absolutely. I would literally do whatever she told me to do. She's just so good. She's so good. No, you have to tip, especially if your server has an attitude. If your server has an attitude, she needs an extra tip, obviously. Obviously, she's having a bad day. Give her $5 extra on top of the tip. $800 though, guys, to private serve at a wedding. You can't sell alcohol. If I were to do that, I would not be allowed to sell alcohol. You need a liquor license to sell alcohol, even at a wedding. But they provide the alcohol. Then they hire a bartender at $25 an hour plus tips for their wedding. Listen, if I ever get married, which I won't, and I'll tell you why. If I ever get married, y'all are pouring your own damn drinks. You might even bring your own. But this is why I'll never get married. I'm driving home from work yesterday and I am exhausted. And the thought breezes by my mind lightly. I wish that there was someone waiting at home I could just unload all this on. Someone I could lean on. This is how quickly that thought vanished. As soon as that thought touched my brain, I wish there was someone at home I could just lean on. Right away, my brain said, sure. If there was someone at home right now, you are exhausted, you are so tired, you're going to walk in the door and they're going to say, what's for dinner? And then you're going to lose it and you're going to find a shotgun. So actually, I'm not in jail right now because I don't have someone at home to have fun. Because if I would have walked in that door and they would have said, hey, what's for dinner? Yeah, nothing would have saved their lives that night. I am wearing a towel. I wrapped around a towel because when I got off work yesterday and got out of my uniform, I didn't have the energy to get pants or a skirt on. I just didn't. I just wrapped up a towel and went to bed. I was not able to get someone dinner. That's true. This person is not so lucky though. We're going to hear about everything that she did.
Police responded to a report of a male shot in the shoulder by a female who was still in possession of the firearm used at a residence in Jackson. Dispatch informed police that the male had locked himself inside the bedroom and did not know where the female suspect was located. Upon arrival, police executed a protective sweep of the property, finding no individuals aside from the victim, initials LS. The victim was found in an upstairs bedroom, and he was alert, conscious, and was able to exit the residence with minimal assistance. The victim was observed with a gunshot wound to his neck and/or clavicle on his right side, and it appeared that the bullet was still lodged in the wound. The victim advised officers that his vehicle was missing, and it was identified as a gray Mercedes-Benz. It was also learned that the suspect, who was identified as this defendant, was still in possession of the firearm, which was identified by the victim as a .22 caliber long rifle pistol. The victim advised that this defendant was a friend of his who was staying at his home. The victim stated this defendant is alleged to suffer from mental illness and had not been taking her medication. On the evening of this incident, the victim and this defendant had been talking about this defendant seeking medical attention because she was experiencing a manic episode. The victim advised this defendant if she did not take her medication, she would have to find somewhere else to stay. The victim alleges that this defendant suddenly retrieved the victim's pistol, which he keeps in his bedroom, and proceeded to point it at him and shot him one time before exiting the bedroom. The victim maintains that he and the victim were not engaging in any sort of argument at the time. The victim was transported to Community Medical Center to receive treatment. Shortly thereafter, Jackson Police was advised that this defendant had been located by Manchester Township Police, and she was taken into custody without incident. When Manchester PD stopped this defendant in the victim's vehicle, the suspect firearm was on the passenger seat in plain view. Manchester police officers on scene advised that this defendant made spontaneous utterances about shooting the victim, which were captured on their body-worn cameras. These statements are alleged to include, quote, "I had to shoot the guy," and, quote, "he's dead," and were made while this defendant sat in the back of the patrol vehicle at the time of her arrest. This defendant was subsequently charged with first-degree attempted murder, second-degree possession of a weapon for an unlawful purpose, second-degree unlawful possession of a weapon, in this case a handgun without a permit, fourth-degree aggravated assault with a firearm, and fourth-degree aggravated assault causing injury with a weapon. Your Honor, the state has had contact with the victim in this matter, initials LS. He strongly believes that this defendant needs psychiatric help and could benefit from a mental health evaluation and treatment. He advised that he and this defendant resided together but have a platonic relationship, as this defendant stayed in a room in the victim's home. The victim confirmed that he was admitted to the hospital.
It's Jersey, guys. It's fine. That's Tuesday. Thank you, Monica.
Following this incident. He is currently considering obtaining a restraining order and is requesting a no contact order and a no return to scene at this time. Your Honor, the nature of this defendant's charges are seriously concerning to the state and warrant this defendant's detention. It is the state's position that this defendant is a serious danger, not only to the victim, but to the community. This defendant is alleged to have used a firearm belonging to the victim to shoot him before fleeing the residence in his vehicle. The state notes that the victim considered this defendant a friend and had even allowed her to stay with him in his own home. When this defendant was confronted with the victim's concerns for her mental health, she is alleged to have reacted in this violent and reckless manner. The fact that this defendant could cause severe injury that could have led to the death of the victim in this matter creates serious concerns for the state, for not only the safety of the victim, but for the safety of the community at large. The state also believes that not only is this defendant a significant risk of danger, but she's also a risk of obstruction. The state fears that even if we do impose a no contact order or a no return to the scene, this defendant will likely try to contact the victim or worse upon her release. Lastly, Your Honor, the state also believes that this defendant is a flight risk. She has no significant criminal history, but she is now facing 5 serious charges, including the first-degree attempted murder and the 2 second-degree charges. If convicted, she is looking at significant prison time. Further, the first-degree attempted murder charge makes this defendant subject to the No Early Release Act, which requires a defendant to serve 85% of her sentence before becoming parole eligible. Having had no history or significant interactions with the criminal justice system previously, at 33 years old and now facing a significant sentence, the state feels that she will be incentivized to flee. For all of these reasons, Your Honor, the state asks that you find in line with the PSA's recommendation and detain this defendant pending trial. Unless Your Honor has any further questions, the state would submit.
Thank you. I don't. Counsel, I'll hear reasons for your client's release.
Thank you, Your Honor. I just wanted to start with reminding the court that my client is innocent until proven guilty. At the appropriate time, defense would express what the issues are in this case, specifically self-defense and their issues of duress, but today is not the day for that. As the PSA does indicate, the scores are fairly mid-range. My client does not have any significant criminal history, and for her to be 33 years old, and this is the first major significant interaction with the criminal justice system, would lead one to believe that there is something significant that caused this type of behavior. And again, that is not for today. We will address that at the appropriate time. But beyond that, Your Honor, as the PSA indicates, she is not on any type of parole, probation, or any type of monitoring. There are conditions of release that would keep the community safe, specifically that mental health evaluation and any substance abuse evaluation, a no contact provision. My client has no interest in having any contact with this individual. That was the issue. She wanted to get out of that house. She wanted to get as far away from that individual as possible. Your Honor, she was previously employed some time ago in New York in a dental office. She does have family in the state of New Jersey. Her mother does reside in Clifton, so she would have supports with her mother, Your Honor. She does need that assistance with that mental health evaluation because having resided with that individual has caused substantial mental health issues for her. Again, we would ask that the court deviate from that PSA recommendation, as the scores are fairly mid-range and the history is limited. So, Your Honor, defense would submit that there are conditions of release that would ensure the triad, and with that, defense would submit.
All right, thank you. All right, this matter is before the court regarding Ms. Rojas's pretrial detention. The court has considered the arguments by the state for her detention. I also considered the arguments by her attorney for her release. This defendant is charged with very serious charges with attempted murder, which I will be addressing. The state has argued that defendant's failure to appear score is a 3 in the middle, going toward the lower end. A new criminal activity score is also a 3 in the middle, going toward the lower end, so mid-level type of scores. To the defendant's credit,
Tina P. Hi, Tina.
there's no red flag denoting an elevated risk of violence upon a release. However, the public safety recommendation is no release recommended. The most serious charge before the court is the attempted murder. There's numerous weapon charges. It appears the weapon belonged to the alleged victim, LS. It appears that this defendant was residing with the alleged victim at the time. It appears he's indicating she has some mental health issues and she needs to take medication. According to the appendix, when they were discussing that, and she was being asked to leave if she did not take that medication, she went to obtain the victim's gun, which is a .22 caliber long rifle, and he shot him. When police arrived, the victim had locked himself in his bedroom, and they checked him, and he had a wound to the neck, the clavicle area, right side, and the bullet also was still lodged in his neck. The alleged victim indicated his motor vehicle had been taken. Through further investigation, the law enforcement were able to locate that motor vehicle. The defendant was there, and in plain view, the firearm was there as well. The alleged victim believes she needs some psychiatric treatment, and also he may be considering a temporary restraining order. One has not been issued yet, but he does request a no contact to himself and also to the residents. Her attorney indicates there may be some issues of self-defense. There's no issues articulated before the court what that would constitute. There may be some issues of mental health counseling, and the court believes that's clearly needed, but she just cannot just be released to the street. If the most favorable will have been a level 3+ of electronic monitoring, 24/7 supervision, and also mental health counseling and possession of weapons. That information is not before the court. So based upon the reasons set forth on the record, this court at this time is going to find by clear and convincing evidence that no amount of monetary bail, non-monetary conditions, or a combination of monetary bail conditions will reasonably assure the defendant's appearance in court when required.
Okay, I have to stop right there because I'm the only one who plays Jersey. You know what? Can we just stop for a second and appreciate we're watching a court in New Jersey right now in Jersey? That's pretty freaking cool. Anyway, in New Jersey, it's not bonds. Like, you don't get a $500 bond, a $10,000 bond cash as surety. You don't have to go to a bondsman. It's not money to get out. So in New Jersey, when you get detained, alright, this isn't for every single case. I'm not saying there are no bonds in New Jersey at all anymore. That's not true. But most the cases that we see now, there's no bond. It's law. When they go for their first appearance, the prosecution has a decision to make at that time. Let them go or hold them. If the prosecution says, I do not want this person let go, I want to hold them, not even the judge can overturn that. That person is there until they get in front of a superior court judge, which is normally within like 3 days. But they're not allowed to be released. Now, then they get in front of the superior court judge, which is this right here. So she has already been in front of another judge, like Judge Nakama, and the prosecutor said, stop, whoa, detain them. They don't have to give a reason why. They don't have to say why. They could just say detain them. And she's been detained. Now she's in front of the superior court judge. He has two options: release or hold. It has nothing to do with bond and how much money she can pay. If he chooses to release her, this judge, then he has to, he doesn't have to, then they can put her on supervision at a different levels. One is call them once a month. That's a real high number. The lower the number, the worse the supervision is. So let's just say it's 5. On level 5, she calls once a month. And level 1 is like she calls every other day, or she goes in and tests every other day. It just depends what level they give her, he gives her to be released. He clearly just said she ain't going nowhere. She is not being released. But it doesn't matter about money, because they don't need money in Jersey anymore for bonds.
The protection or safety of any other person or the community, that defendant will not obstruct or attempt to obstruct the criminal justice process. Before I conclude, the court gave considerable weight to the language that was used of her intention, that she wanted this person to be dead. She told the police, I had to shoot the guy. He's dead. So that's of a concern to that individual and to the community.
Sherry, did this just happen, or was this like a long time ago? And when you say your brother-in-law, Is his wife your sister?
I'm going to grant the state's request for pretrial detention at this time. There will be no contact to LS or to his residence, and a violation of a no contact condition shall result in one or more penalties and consequences. Ms. Rojas's next court date will be before Judge Ryan, and that will be December 9th at 9 o'clock. Anything further by the state?
Nothing further, Your Honor. Thank you.
Anything further by defense?
Nothing further, Your Honor. Thank you.
All right, Ms. Rojas, that concludes your matter at this time.
Anyone claims to have a normal family is lying. Thank you, Kelly. Half of my family are normal, though.
I can start going down the list if there's no case that needs priority. And that next case will be the Barker case.
Bob Barker, come on down.
All right, the court will be addressing the state versus Anthony Barker under warrant W-2025-330-1533. Before we go on the record, I'm just going to ask Ms. Adams whether there's going to be any objection to any of the state's items in evidence.
Your Honor, no objection to any of the state evidence.
And will there be a stipulation of probable cause for purpose of
For the limited purposes of today's hearing, defense would stipulate as to probable cause.
All right, with that understanding, Mr. Barker is charged with a second-degree aggravated assault. I'm going to ask the state to enter their appearances, just indicate whether they're ready to proceed.
Thank you, Your Honor. Assistant Prosecutor Florencia De Paula appearing on behalf of the state, and the state is ready to proceed.
Thank you. Ms. Adams, you can enter your appearance.
Good morning, Your Honor. Michelle Adams, Office of the Public Defender, on behalf of Mr. Barker, who is present, and the defense is ready to proceed.
All right, thank you. Mr. Barker, you can state your name for the record.
Anthony Barker.
All right, Mr. Barker, when you were brought into custody, did you see the first appearance video?
Anthony gets me again. It's always Anthony that gets me. His name could have been Bob. Lots of people's names are Bob. It's a good chance his name is Bob. We had a good chance of getting a Bob Barker. And now we got an Anthony Barker.
Yes, Your Honor.
All right. Did you either receive copies of the aggravated assault charge, or did your attorney explain it to you?
Yes, Your Honor.
Did you hear me read the detention rights this morning?
Yes, Your Honor.
And did you understand those rights?
Yes, Your Honor.
All right, thank you. Prosecutor, you can proceed placing your items into evidence. Then I'll do my introduction, and then you can receive your argument, followed by defense attorney's argument for her client's release.
Thank you, Your Honor. The state submits S1, the certification in support of pretrial detention, relying upon the grounds set forth therein. The state, with regard to probable cause, the state would rely on S3, the complaint, specifically the affidavit of probable cause. The state will also submit and rely upon S2, the PSA, and S4, the defendant's CCH.
Thank you. The court has reviewed S1, the certification, and E-courts. The court will find the motion for pretrial detention has been properly filed in this matter. Regarding the eligibility for detention, it is alleged that the charge involves a second-degree charge. It is also alleged involves domestic violence. It is also alleged there's a serious risk. Defendant will not appear in court as required. He will pose a danger to another person or the community, and/or defendant will obstruct or attempt to obstruct justice, or threaten, injure, or intimidate, or threaten, or injure, or intimidate a prospective witness or juror. Eligibility has been established, and the state's in agreement with the eligibility is set forth in their S1. Mr. Barker indicated he heard and understood the detention rights, so we're going to move to the issue of probable cause. However, his attorney did indicate for purposes of this detention hearing only shall stipulate to probable cause, and this court has reviewed the state's items in evidence regarding probable cause, underscoring the complaint and also the affidavit probable cause, the court will find that probable cause has been established for purposes of this detention hearing. I'm going to hear from this time, and the court will note that there's still a rebuttable presumption against detention. I'm going to hear the state's arguments followed by defenses. Prosecutor, you can proceed.
Thank you, Your Honor. On October 24th, 2025, police responded to an incident involving domestic violence. The victim, initials RZ, advised that this defendant, who is the father of her child, had assaulted her. She had come to stay at this defendant's residence with the child as the heat in her own home was not working. The victim further advised that she asked this defendant to tell his friends who were at the residence consuming alcohol at the time to leave so that the child could go to sleep. This defendant grabbed the victim's neck and restricted her airway for approximately 15 seconds before releasing his grip on her neck. Then he placed his hands over her mouth to prevent her from speaking. The victim then was able to retrieve her belongings and left this defendant's residence. Your Honor, while the state concedes that this defendant's PSA scores are low, the facts and circumstances of this offense are very concerning. This defendant is alleged to have strangled this victim by restricting her airway for about 15 seconds, and then after releasing his grip on her neck, he placed his hands over her mouth to prevent her from speaking. The state is grateful that the victim was able to leave the defendant's residence after the assault and was able to make it somewhere safe. The state takes these allegations of domestic violence seriously and believes that this defendant is a danger to this victim. The state has been in contact with the victim, initials RZ, who is in favor of detention at this time. The victim believes that this defendant is an alcoholic and that she obtained a temporary restraining order and does plan to pursue a final restraining order. She has one child as a defendant who is included currently in the temporary restraining order. The victim is requesting a no contact order and detailed to her office that she has suffered significant verbal and mental abuse from this defendant. Lastly, Your Honor, although this defendant has no failure to appear history, the state has concerns that the defendant may be incentivized to flee. He is facing a serious charge of second-degree aggravated assault for strangulation, flagged as violent and domestic violence related, and this charge would make him subject to the No Early Release Act. If convicted, he would be required to serve 85% of the sentence before becoming parole eligible. Because this defendant may be facing prison time, the state believes that this may create an incentive to flee, resulting in this defendant failing to appear in court as required. For these reasons, Your Honor, the state respectfully requests that Your Honor deviate from the PSA's recommendation and detain this defendant pending trial. Unless Your Honor has any further questions, the state will submit.
I don't. Thank you, prosecutor. Ms. Adams, I'll hear from you at this time.
Thank you, Your Honor. Your Honor, defense would request that ask that the court follow the PSA. These are the lowest scores possible, a 1 and a 1, and the PSA does recommend release on monthly reporting. As the PSA indicates, my client has no history. He's not on any form of monitoring, no probation, no parole, no prior history of any kind. Essentially, he has spent 27 years in Ocean County all of his life and has not had any interaction with the criminal justice system. Your Honor, as the reporting indicates, he was at his residence and this alleged victim came there and got into an altercation with him while there were members of
Ms. Adams, you froze.
add up.
Ms. Adams, I'm going to ask you to stop at this time and then repeat your last 3 sentences. But we're frozen now. Can you?
Your Honor, I believe the internet's not working. Your Honor, can you hear me?
Yes, it's going in and out, and sometimes you freeze, and I miss a sentence or two. So if you
Okay.
could go back to the last 3 sentences, then it'll be helpful. All right?
Yes, Your Honor, I apologize. The
No,
internet.
that's not your fault. But go ahead.
Yeah. Your Honor, what I was saying is that I would request that the court follow the PSA.
Yes.
My client is a lifelong resident of Ocean County.
Mhm.
He was residing at his home with his mother, his grandmother, and as the reporting indicated, he had some friends over. So the allegations don't sound quite credible with a household full of people that this incident took place as alleged. As the reporting indicates, the alleged victim was able to leave the house, but my client did advise me she shortly thereafter returned to pick up some ice cream. And she also left the child at the home with my client after she left the residence. Again, he is a 1-1, Your Honor, a lifelong resident of Ocean County. He is a union member of the Local 5. He is an elevator contractor. He resides with his family. He can return to that house. The victim has a separate home, separate and apart from him. As the prosecutor indicated, there is a temporary restraining order. My client has no interest in having further contact with her. He does want to, however, continue to work and provide for his family, both his son as well as his biological, his mother, his grandmother, and his 2 brothers also reside with him. He attended Barnegat High School and then completed Ocean County VOTEC, where he got his where he was educated to work in that elevator contracting field. So that with that, Your Honor, defense's position is there are conditions of release if the court is so inclined to order a anger management. My client is open to that. However, at this time, defense's position is that the prosecutor simply has failed to meet their burden by clear and convincing evidence that there are no release conditions that would ensure the triad. And with that, defense would submit.
Counsel, I do have some questions for your client, not about the facts and circumstances. May I proceed?
Yes, Your Honor. Thank you.
Mr. Barker, can you hear me?
Yes, sir.
How old are you, sir?
I am 27, Your Honor.
All right. Are you a lifelong resident of both New Jersey and Ocean County?
Yes, sir, my whole life.
All right, thank you. You went to Barnegat High School?
That is correct, sir.
Did you graduate?
No, sir. I'd actually left high school to help provide for my family as my grandfather.
How far did you go? How far did you go in high school?
11th grade, sir.
11th. But you went to Ocean County VOTEC, is that true?
Yes, sir. I went there from 9th grade to 11th grade, sir. Or 12th grade, I'm sorry.
And did you receive any certificates?
No, sir.
Okay. But you're a union contractor. What's the nature of your work?
So I'm a union member through Local 5 Elevator Constructors. I build elevators.
How long have you been doing that for?
8 years in total, and then 6 years in the union.
Okay. So just approximately during those 8 years, approximately, I know it fluctuates, approximately how many hours a week are you working?
I'm working 40 to 60 hours a week, sir.
All right, that's an answer. Thank you. All right, that's all the questions I have of you. All right, this matter is before the court regarding Mr. Barker's pretrial detention. The court has considered the arguments by the state for his detention. And also considered the arguments for his release by his attorney. The state recognizes and the defense has argued that defendant's scores are the lowest. He has a 1 for failure to appear and a 1 for new criminal activity. To defendant's credit, there is no red flag denoting an elevated risk of violence upon his release. The public safety recommendation is favorable to the extent it recommends release with monthly reporting, which is level 1 conditions. But the state's argument is only a tool and should not be substituted for the court's discretion pursuant to the case CW. There's allegations that the alleged victim or Z's home was without heat. She has their child in common between her and the defendant. She sought the defendant's housing because of heat. When she arrived there, she observed individuals allegedly drinking alcohol, and she requested by the defendant for them to leave so the child could go to sleep. As a result of that, it looked like they allegedly irritated the defendant, but they're taking issue with that. And it's alleged that he had grabbed her by the neck and also placed his hands on her mouth, and she was able to leave with her belongings, but it's alleged that she returned for ice cream and she had left the child there. So those are issues that are going to have to be addressed at a later time in a later place. She wants the defendant to be detained, and it looks like she has a temporary restraining order, and which includes the child on it, and she's probably seeking a final one as well. As argued by his attorney, he has no other considerable record, no pending charges, no disorderly persons convictions, no indictable convictions, no violent convictions. He's never failed to appear the past 2 years or older. He's never served 14 days or more. He's not on probation. He's not on parole. He's not on any pretrial monitoring. He has no juvenile record. He's a lifelong resident of both New Jersey and Ocean County. He did attend Barnegat High School up until 11th grade. He also attended Ocean County VOTEC
Thank you,
between the
Martha.
9th
Thank
and
you.
12th grades. He's been a union contractor. No, he's been a contractor for about 8 years, a union member for about 6. He works approximately between 40 and 60 hours per week. Based upon the reasons set forth on the record, this court's not going to find at this time by clear and convincing evidence that no amount of monetary bail, non-monetary conditions, or a combination of monetary bail conditions will reasonably assure defendant's appearance in court when required, the protection or safety of any other person in the community, that defendant will not obstruct or attempt to obstruct the criminal justice process. I am going to grant the defendant's release from pretrial monitoring. I am just going to elevate it one level to level 2 based on the charge of second degree, the allegations of choking, put his hand around his mouth. But again, that's going to be contested for purposes of detention. That's the reason why I'm elevating it. He's to have no contact with the alleged victim, whose initials are RZ. A violation of a no contact condition shall result in one or more penalties and consequences listed on the release order under notice to defendant, if also subject to existing domestic violence restraining order, temporary or final from the family part. A violation of a no contact provision of that domestic violence restraining order may constitute either civil or criminal attempt and may result in your arrest, prosecution, and imposition of fines and sentence. Defendant should not leave the country without written approval from a judge having jurisdiction over this matter. He's to have 12 hours of anger management that can be done virtually. He's to refrain from excessive use of alcohol, a substance use evaluation within 7 days, and comply with that. Any contact with his child will be through the restraining order and or family court. And again, no contact with RZ. What's the initials of the child, a prosecutor?
Just a moment, Your Honor. I don't have that handy. I
All
can
right.
look it up.
But the child they have in common, that'll have to be through the TRO or the restraining order, because it could be a final, and also through family court. The defendant's next court date will be Judge Palmer, December 8th. He has to contact pretrial services tomorrow, and that'll be October 30th between 11:30 and 4. There will be a telephone number on his release paperwork. Level 2 conditions are as follows. Defendant is required to report to pretrial services telephonically once per month and in person once per month. Shall appear for all scheduled court proceedings. Immediately notify pretrial service staff of any change in address, telephone number, or other contact information. Not commit any offense during the period of release. Defendant shall refrain from excessive use of alcohol, any use of a narcotic drug or other controlled substance without a prescription by a licensed medical
Martha, thank you for trying. That was a good try.
practitioner. Mr. Barker, you are going to receive written copies of each and every one of the conditions I've stated to you. However, he has to be unmuted. However, did you hear and understand each of those conditions?
Can you say that again, Your Honor?
Yeah, sure. You're going to receive written copies of each and every one of the conditions I stated and read to you. However, did you hear and understand each of those conditions?
Yes, Your Honor.
Can you follow each of those conditions?
Yes, Your Honor.
Ms. Adams, would you be so kind to submit the defendant's address and telephone number?
What a good question. This is New Jersey, Ocean. This Jersey. We're going to see Snooki soon. Any minute now.
to the moderator so it's not placed online?
Yes, Your Honor, I'll provide the court with that.
All right. Anything further by the state?
Nothing further, Your Honor, and I do apologize. I do not have the child's initials at this
All
time.
right, so the one they have in common will have to be through that order through family court. Anything further by you, Ms. Adams?
Nothing further, Your Honor. Thank you.
All right, Mr. Barker, that concludes your matter. You're free to leave. Have a good day.
Thank you, Your Honor.
You're welcome.
Okay, the next case is good, but it's really long and drawn out. So we're gonna move on. I don't know if you remember the other day. We had two, like, I didn't know what I wanted to play, and I played one courtroom, which I can't remember what it is. I think it was Georgia, probably. And I said, and then I showed this at the very end.
3798.
And I said, oh, we were going to do this one, but I picked the Georgia instead. And I think the Georgia was really good. I just can't remember what it was. But we're going to do the other one today. Because this guy is great. Judge Claymore from Indiana is just so good.
In 8907, the defendant is sentenced to 180 days in a Porter County jail, all suspended to administrative probation. So the probationary sentence in 3798 is now concluded with the defendant released unsatisfactorily. The probationary sentence in 89.
I'm usually more memorable, CJ. I'm going to have to up my game, guys.
07 of 180 days now begins to run. Any bond release is for payment of all fines, fees, and costs in 8907, including a $100 public defender assessment.
It was the one before that, because I knew I was playing the judge in trouble the day I played that. It was the one before that, I think. I have eggs and toast that just got dropped off with coffee right now because I'm starving, and I'm going to eat it. I'm going to go and I'm going to get it, and I'm going to eat it.
A judgment liens for any fines, fees, and cost. Restitution is not part of the agreement. It was de minimis. Good luck to you, Ms. Imbicky.
Report to probation, take that to me.
She need to see you, Ruth, or?
Needs to go over because we do
Be right
have
back, getting my
administrative
coffee.
rules assigned.
All right. You need to go report to probation.
Thank you.
Scott Barron will be next. Your Honor, this is State of Indiana versus Scott Barron, cause number 64 D02 2507 F6 7572. Defendant appears with counsel Mr. Peters. State appears by Deputy Prosecutor Holman. Here today for an omnibus. However, I believe parties will be submitting a plea today.
Will you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
What is your name?
Scott Barron.
How old are you? Do you understand English? Are you under the influence of any drug or alcohol? Do you have any mental or emotional disability? Did you sign a plea agreement? Was signing the plea agreement your own free and voluntary act? Do you understand that if I accept the agreement, I must sentence you the way that it is written? Do you understand that?
Yes.
Do you also understand that if I accept it, you're waiving your constitutional rights that are set forth in writing? Do you understand that as well?
Yeah.
Mr. Peters, set forth the terms.
Certainly, Judge. Scott would plead guilty to count 1 criminal recklessness, a level 6 felony. He would be sentenced to 540 days Porter County Jail, suspended to administrative probation, credit for 2 actual days served, July 8th and 9th, 2025. And he is not to possess a firearm during the terms of his probation. Those are all the terms, Judge.
Mr. Barron, is that your understanding of the plea agreement that you signed? Factual basis.
Certainly. Scott, on July 8th, 2025, you were in Porter County, Indiana, correct? Yeah. And you fired a pistol into an abandoned mobile home in a trailer park, correct? And you acknowledge that that created a substantial risk to other residents of the mobile home park, correct? And that you were armed with a deadly weapon when that occurred, correct? No further questions, Judge. I'll stipulate to the probable cause affidavit as per the factual basis.
C stipulates nothing further.
I accept the agreement the way that it is written. I enter judgment of conviction under count 1, criminal recklessness, a level 6 felony. The defendant is sentenced to 540 days in a Porter County Jail, suspended to administrative probation, credit for 2 actual days served on July 8th and July 9th, 2025. As a specific term of probation, the defendant is not to possess any firearm during the term of probation. That means a rifle, a shotgun, a pistol, a revolver, a semi-automatic, a blunderbuss, no guns. Do you understand that? Now, as that's the sentence in this case. As a convicted felon, would this then affect Mr. Barron's right to possess a firearm in the future? So I don't want the part of the plea that says the defendant is not to possess a firearm during the term of the probation. This does not necessarily mean then that as a convicted felon, he may do so afterwards. I just want to make sure that we're all on the same page at this point. This does not mean in and of itself that Mr. Barron may possess a firearm afterwards, does it?
No, it would not.
I mean, he wouldn't be Brady disqualified to possess a firearm, but as a convicted felon, he would be disqualified from possessing a firearm even after the probationary sentence is done,
Perhaps.
unless his rights to possess a firearm are restored. Well, that's not part of the plea, but I would check into whether it's legal to possess a firearm as a convicted felon before you attempt to buy a. Do you possess any firearms now? You may not, as a condition of your probation for the next 540 days. I'm not telling you whether you can or can't once your probation is done. Do you understand that? Good luck to you.
Okay, good luck. Go report to probation, take that to him.
That's $500 cash.
CPD.
Just apply it to fines, fees, and cost balance to poster if there is any.
Carolyn Saxbury will be next.
$100 to county.
Your Honor, this is State of Indiana versus Carolyn Saxbury, cause number 64 D02 2507 F66731. The defendant appears with counsel, Mr. Peters. State appears by Deputy Prosecutor Holman. Here today for an omnibus. I believe parties will be submitting the plea.
You've asked.
Will you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? What is your name? How old are you?
40.
Do you understand English? Are you under the influence of any drug or alcohol?
No.
Did you sign a plea agreement? Was signing the plea agreement your own free and voluntary act? Mr. Peters, could you set forth the terms?
Certainly, Judge. Carolyn would plead guilty to amended count 1 possession of a controlled substance, a lesser included class A misdemeanor. She would be sentenced to 1 year or 365 days Porter County Jail, all suspended to administrative probation, credit for time served, judgment lien for all fines, fees, and costs. Just so the court's aware, because there have been some positive screens in this case, she is scheduled to go into regional, and although we didn't provide that in the plea, she does have that intake scheduled. So having said all that, those are all the terms of the plea, Judge.
Ms. Saxbury, is that your understanding of the plea that you signed? Factual basis?
Certainly. No.
Listen to Mr. Peters.
Carolyn, on July 8th, 2025, you were in Porter County, Indiana, correct?
Yes.
You came in contact with a law enforcement officer
Yes.
and he found you in possession, or you had in your possession, controlled substance schedule 1, 2, 3, or 4, correct?
Yes.
And you did not have a prescription from a practitioner for that substance, correct?
Correct.
And you knew that you had that in your possession, correct? No further questions, Judge. I'll stipulate to probable cause affidavit as a further factual basis.
State stipulates. That's further.
I accept the agreement the way that it is written. I enter judgment of conviction under amended count 1, possession of a controlled substance, a lesser included Class A misdemeanor. The defendant is sentenced to 365 days in the Porter County Jail, all suspended to administrative probation with credit for time served from July 8th through July 10th, 3 actual days. Judgment liens will be entered for all fines, fees, and costs. There's a $200 drug abuse prosecution, interdiction, and correction fee. Restitution is not part of the agreement. Good luck to you, Ms. Saxbury.
Good luck. This minute, she's gonna give you a copy, take it to motion. Take that over to 157. Reference to Paul.
Jasmine Powell be next. Your Honor, this is State of Indiana versus Jasmine Powell, cause number 64 D02 2406 F6 6611 and 64 D02 2406 F6 6612. Defendant appears with counsel, Mr. Peters. State appears by Deputy Prosecutor Holman. Here today for a status. However, I believe parties will be submitting a plea.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? What is your name? Ms. Powell, how old are you? Do you understand English? Are you under the influence of any drug or alcohol? Do you have any mental or emotional disability? Did you sign a plea agreement? Did anybody force you to sign that plea agreement?
No.
Do you understand that if I accept the agreement, I must sentence you the way that it is written, even though it's an argued sentence? Do you understand that?
Yeah.
And do you understand that if I accept the agreement, you're waiving your constitutional rights that are in writing in the agreement as well? Do you understand that? Mr. Peters.
Judge, in 6612, Jasmine would plead guilty to count 1 fraud, a level 6 felony. In 6611, she would plead guilty to count 1 fraud, a level 6 felony. Remaining counts dismissed in both causes. Would argue sentence, credit for time served, 2 actual days. She would also be given credit for her completion of substance abuse treatment at South Suburban Council, and for her participation in compliance with treatment alternatives for safe communities. Sentence would be consecutive to the Cook County, Illinois case. And that cause number is set forth. Sentences in these matters are to be concurrent to each other. Restitution is to be paid in full upon submission of the plea, and any probation may be transferred to Illinois upon payment of $355 transfer fee by counsel's trust check. Restitution, fines, fees, and costs are to be paid from the bond and from the funds that are held in my trust. And by my calculation, there's sufficient funds between those two things to accomplish all of the restitution, the transfer fee, and the court costs. Restitution is in the amount of $2,095.99 to be divided between Kohl's, Walgreens, Myers, and Terra Merit as allocated by the state. So in their restitution figures, they can tell us what's what and where it goes, but I have the money. Other than, I will also need to utilize the bond as well. Those are all the terms, Judge. We do anticipate a PSI. So I'm asking upon acceptance of the plea that she be set for sentencing at PSI be.
Ms. Powell, is that your understanding of the plea agreement that you signed?
Yes.
Factual basis, Mr. Peters.
Certainly, Judge. You think I'd be ready by now. Okay. On October 19th of 2023, you were in Porter County, Indiana, correct?
Yes.
And you used or attempted to use a stolen credit card, correct?
Yes.
And you did that with the intent to deprive the owner of the value and use of that property, correct?
Yes.
And then on. What was the date?
November 7th.
11/7, limited.
One date's October, one date
Oh, yeah.
November 7th.
Ms. Powell, you were in Porter County, Indiana on November 7th, 2021, correct?
Yes.
And specifically, you were observed removing something from somebody's purse, correct?
Yes.
And and that was some sort of credit card or Kohl's card or some sort of credit card, correct?
Yes.
And you admit that you used that card and made multiple purchases at other retailers, correct?
Yes.
And you would agree that the loss there was exceeded $750, correct?
Yes.
And you agree by using that credit card that was issued to somebody else, you created a false impression in another person pursuant to the fraud statute, correct?
Yes.
Thank you, Your Honor. Nothing further on that. State would stipulate to the probable cause affidavit and in both causes to further supplement factual basis.
As will the defense.
Right. So, and I understand that then there's an agreement of restitution in the amount of $2,095.99 to be allocated then between Kohl's, Walgreens, Myers, and the specifically named person in the plea agreement. And that information will all be provided to the court at sentencing at the conclusion of a PSI, which the court is now ordering. Based on that, Mr. Peters, when should we set this matter for
Let's not-
sentencing?
Let's not do it the same day as Tamika. Let's pick another day. December, late December, sometime late December, and you'll have to be here. And you'll have to cooperate with probation on preparing the PSI.
And did we just set Tamika on the
Man,
15th?
I'm with
We
you.
set her in January, so 12/15 would be fine.
Ms. Powell, you are ordered to be here December 15th at 9 o'clock for sentencing, but you're also ordered to report to probation for the preparation of a pre-sentence investigation report. You understand that? Mr. Peters will explain that to you. I'll
I
see you.
gave her the address. She knows where to
I
go.
was too
Give them
late.
that
I
copy. That's
apologize.
for them. And they'll give you some paperwork to fill out.
I'll see you in December.
Right across, it's down to the left, one block down.
Thank you.
Yep, good luck. Richard Perry.
Richard Perry will be next. Your Honor, this is State of Indiana versus Richard Perry, cause number 64 D05 20, I'm sorry, D02 2501 F6763. Defendant fails to appear. Oh, I'm sorry. The defendant appears via Zoom. Appearing on behalf of the defendant is counsel Mr. Peters. State appears by Deputy Prosecutor Holman. You're here today for a status hearing.
Judge, I have a plea agreement. I just need Mr. Perry to,
I'm not gonna lie. I got 1, 2, 3, 4. But you want to know something? I know it's see-through because of my screen, but you know it is not. The only reason why I got this horrible, disgusting coffee this morning, the only reason I got it, for real, that I spent money there, is I wanted one of these, I can't make it show up, Monopoly pieces. And there's no Monopoly piece. Anyway, you know what I really absolutely thought that guy was? I was just sure he was an attorney. I really was sure he was an attorney, and he's not. I was waiting for him to talk.
get here. I understand he had some transportation issues today. I'm just asking for something a few weeks down the road.
All right. And I understand that there were.
Wait. What? What do you mean transfer? Isn't he in the hospital? That's not the hospital? That's his house? Is that his house?
Transportation issues. Can you hear us now, Mr. Perry?
Yes, sir.
All right. Can you make it to court in person November 17th at 9:00?
November 17th at 9. Yes, sir.
You are ordered to appear in this court for a status hearing November 17th at 9:00 in person. So you need to work out transportation ahead of time. Do you understand that?
Yes, sir.
I'll see you November 17th at 9:00.
See you
Thank
then,
you, Your Honor.
Richard. Thank you.
Thank you. Thank you both.
All programs.
Your Honor, this is State of Indiana versus Robert Paul Bellows. Cause number 64 D02 2505 F6 5011. Defendant fails to appear. Appearing on behalf of the defendant is counsel Mr. Peters. State appears by Deputy Prosecutor Holman. Here today for a change of plea hearing.
Huh. Well, we know where. Mr. Bellows, are you in the courtroom? No. We know where he's not. Do we know where he is, Mr. Peters?
No, Judge, this is the gentleman that has repeatedly attempted to transmit the signed waiver of plea to me by email through his son's phone or something. And apparently he's technologically impaired, as I am. And so for whatever reason, I don't have the signed agreement. You set this, I don't know, a few weeks ago, I think.
So I
He
am.
was on Zoom a few weeks ago.
So I'm now vacating all previously issued dates and issuing a warrant for his arrest for failing to appear.
And I will attempt to contact him and maybe get it reset.
If he shows up next Monday
That's
before
amazing, T.
he's arrested, then the warrant will be recalled. If he's arrested before next Monday, then we'll give him a ride.
Thank you, Judge. And I'm sorry that all took so long.
It's not your fault. March, band out.
Christopher Tabler.
Tracy.
Your Honor, this is State of Indiana versus Christopher Tabler, cause number 64D02-2410 F6-10930.
And then you
Defendant
woke
who
up.
appears with counsel, Mr. Woodward. State appears by Deputy Prosecutor Holman. Here today for a change of plea hearing.
Your Honor, we are set for change of plea hearing, but I'll take the hit on this one. I let it fall through the cracks. In all honesty. So, we could have a short date, perhaps, November 17th, if we're resetting that quickly. I will work hard to have a disposition.
We could do two things. What day do you want?
I was going to say November 17th, which is a Monday.
All right, we can set this matter for a status November 17th at 10 o'clock. And we can go ahead and probably put it on the trial calendar too, just
That would be fine.
the courts
Keep
had
it rolling, yes.
some
I
concerns
agree.
about Rule 4. So this matter is set November 17th at 10 o'clock for a status, and we need to get a different calendar. Don't we? Matter is set for jury selection January 26th at 1 o'clock. So I'll see you in November for a status. If it's not resolved, I'll see you in January for a trial.
There you
Okay.
go. Thank you, Your Honor.
Thank you, Mr. Wilson. He's been in and out.
Howell. Your Honor, this is State of Indiana versus Brian Howell, cause number 64D02-2406 F6-6264. Defendant appears with counsel, Mr. Barnes. State appears by Deputy Prosecutor Holman, here today for an omnibus. I don't have to. All right, move it.
Judge, we're still working through the discovery process. I just reaffirmed the final pretrial conference date of November 24th.
It is affirmed. Mr. Howell, you are ordered to appear in person once again. Do you understand that, sir? I will see you then.
Thank you, Judge.
What a waste of his time. He drove the whole way down here for this. He took the day off work.
I'm just gonna go.
Okay, thanks.
I believe Mr. Chargoloff is it. Mr. Chargoloff, who's your client?
We Copeland.
We get to see Mr.
Copeland,
Chargoloff.
and
Look,
there was an issue with this.
look. We get to see Mr. Chargoloff for once. He's always in Christofino's courtroom. We can't see him. Right there he is.
Setting, Your Honor, I'm not sure if it was some type of Demarius Harrell is also on the docket for today.
Is Demarius Harrell here? Mr. Harrell's here.
Call that one?
Yeah.
Your Honor, this is State of Indiana versus Demarius Harrell, cause number 64D02-2507 F57841
It's not.
and 64D02-2507 CM7972. And
Okay, when I said that they wasted his time, he drove the whole way in for that. What I'm really thinking in my head is they just wasted my time with a nothing. Something better happened here, Mr. Chargoloff.
64D02-2509 CM10420. Defendant appears in person. Counsel, Mr. Chargoloff, appears via Zoom. Here today for a status on all matters. Looks like there's some pretrial service violations pending.
Judge,
Mr. Chargoloff.
on behalf of Mr. Harrell, I need to meet with him to further discuss some of those allegations. Additionally, the court will notice this is actually there's the highest charge, excuse me, is an F5. I'm not sure how we ended up on the Monday call. So I'd ask the court to vacate any of the dates currently set and reset us on the appropriate without moving his January 5th, 2026 trial date, which has already been set, Judge. I just ask that we reset this for a Wednesday, please.
The court takes judicial notice of two things. The court takes judicial notice of criminal rule 4 regarding the trial setting in January, which will be 1 o'clock on a Monday. The court also takes judicial.
Alan, that's unsustainable. It's literally impossible. I don't know what the percentage is. It's a very small percent right now that goes to trial. Everybody else takes a plea. If we would have everybody go to trial, we couldn't do it. There's not enough courtrooms just to get through what we have this year. We would be shut down for the next so many years. It wouldn't work.
Notice that the highest level charge in 7841 is a level 5. So then the companion misdemeanor cases should also be heard on a Wednesday. So the trial date in January is affirmed. How does December 3rd is that the prosecutor's? All right. How does December 3rd at 9 o'clock work, Mr. Charkoloff?
That works for my calendar, Judge.
All right. The trial setting is affirmed in January, and these matters are all now set for a status December 3rd at 9 o'clock. Mr. Harrell, you are ordered to appear December 3rd at 9 o'clock. Do you understand that? Mr. Chargoff, do you need to speak with your client? I'll tell him right now you're talking in front of the public, but you may need to speak to Mr. Chargoff.
Mr. Harrell, just contact my office, please.
Okay. All right. We'll see you in December.
Thank you, Judge.
Ms. Copeland's here.
Brittany Copeman. Your Honor, this is State of Indiana versus Brittany Copeman, cause number 64 D022507 F67828 and 64 D022507 F67748. Defendant appears with counsel Mr. Shargaloff, who appears via Zoom. State appears by Deputy Prosecutor Holman. Here today for a change of plea hearing, and I believe there is a recent pretrial violation filed, if I remember.
Judge, well, I'm sure we can hopefully reach a resolution in this case. Part of the issue has been I was not quite sure who I should be speaking with on the level 6 felony cases in your court. That's become clear. I think at this point need a chance to speak to Mr. Pavlovsky, given some circumstances with the change in prosecutor. So I'd ask the court for one additional setting.
Miss Pavlovsky is not here, right? No. Josh, okay, listen, I got my days messed up. Did you get home yesterday, right? Or are you flying now? I don't see you're here. I just see that Monica said hi to you, and so did JK. But I don't see you. You're not showing up in my chat that you walked in the door. So maybe everybody else is drunk, and I'm right, but did you get home yesterday, or are you flying today?
For denial as to the allegations contained in the pretrial violations.
So Ms. Copeman, you had a drug test that was taken on September 11th, and it allegedly tested positive for certain drugs. Do you understand that? And Mr. Chargaloff, on your behalf, has denied those allegations. You're entitled to a hearing on those allegations. So how far out should we go, Mr. Chargaloff, on everything?
Could we go 30 days, please, Your Honor? End November, beginning of December would be fine.
And these will be set on a Monday, and you know with whom you are to speak regarding resolutions within the prosecutor's office now?
I will.
Mr. Holman, can you help out?
Oh, yes, Kiri. I apologize.
Okay, understood.
These matters are now set for,
Kathy is almost always drunk. I wish that was a lie, guys. It was just a lie. It was just what I wish was true.
status November 17th at 9. Does that work, Mr. Chargoff, or 10?
Good,
Whatever's
Josh.
better for
Good.
you.
I'm proud of you.
10 would work better, Judge.
Ms. Copman, you are ordered to report to this court in person November 17th at 10 o'clock. Do you understand that? All right. Call Mr. Chargoff.
Thank you, Judge.
Oh, but hold on, Mr. Chargoff. Any other dates that we set are now vacated because there were others. That November date stands, and the delay is charged to the defendant under criminal rule 4. Or do
Thank
we
you.
want to keep the other dates for rule 4 purposes? What makes most sense from your client's perspective, taking into consideration rule 4?
Judge, this is one of those situations, I would not be prepared to go to a trial.
Which court ordered class did you have to take again? Was it domestic violence class? That's what it was, T.
I need more time to speak with my client, so I'd accept the delay under Rule 4, ask the court to vacate. That status date that we set, I can advise the court at that point whether or not we need a trial setting.
All right. All dates previously entered are vacated.
You're
The
right,
delay
Bobby.
is charged to the defendant under criminal rule 4. Ms. Copman, I'll see you at the date that I just told you, and I've already forgotten it. So.
Yeah, I was in, I'm sorry. What was the date? November 17th.
November 17th at 10 a.m. Got somebody who's smart, so
Thank
we'll
you,
see you
Judge.
then. Ms. Charkoff, do you need to speak with your client?
Brittany, reach out to the office. That way we have updated contact information, okay, if anything's changed?
Yes, I contacted your office on Friday with all of that. And I didn't.
Perfect. All right, then we have it. Thank you.
Thank you.
Is Andrew Garcia here? Here, this is State of Indiana versus Andrew Garcia, cause number 64 D02 2507 F6 7894. The defendant appears pro se, state appears by Deputy Prosecutor Holman, here today for an omnibus hearing and an attorney status hearing.
Mr. Garcia, have you been able to hire a lawyer?
No, I never, when I was originally arrested, I had a hold on me from a different county. I just got out of jail 9 days ago. So if I can get more time.
Are you going to have a job, or do you have a job back now that you're out of jail?
Well, my old job said they're gonna hire me back. I'm just waiting for them. I already put in my application. They said they'll hire me back as a magistrate.
All right, let's do this. What I'm going to do is just reaffirm the dates that I gave you before. Nothing bad will happen. But the next date that I had previously ordered you to be here was October 20th. Should we switch it to 10? Right now, Garcia. Let's do this. October 20th, but not 9 o'clock, but now 10 o'clock.
That's today.
I thought
All right, we're gonna
so.
skip that. How
Okay,
about
okay.
November 24th at 10 o'clock? And right now, we're just reaffirming the trial setting, but if you don't have a lawyer, we'll address those at this point, but
Is it possible to get it in December?
we could do that.
Just because I'm kind of backed up on bills and stuff.
Well, that happens when you're in jail. I
Heck
understand
yes.
Sounds-
New Jersey court is great.
that. All right. This matter is set now for a status conference December 15th at 10 o'clock. We'll give you a no. All other dates that I told you to show up before, even though I've got my dates confused, are now
Just a little,
vacated.
Judge.
The delay is charged to you under criminal rule 4.
Okay, all right, listen. We've heard enough. He's not going to say anything. It's I'm going to just bump it. Oh, that's it. All right, we'll finish. Nothing happened today. He's so good and we got nothing. All right, we'll go to this guy. This might be our last one.
Or D02 2510 F6 10989. Defendant appears pro se. State appears by Deputy Prosecutor Holman. Here today for a status hearing. On a probation revocation matter. Actually, I don't know why it's not on my list. I have another file too for 64 D02 2510 F6 10989 for an F6 methamphetamine case.
And it was transferred in from Judge Matsey, it looks like, on October 2nd.
That's what my notes show.
Judge Massey. I don't know that
Set for a
judge.
status today. All
I've
right,
never
that's
heard
on
of him.
10989.
I just believe we need a admit deny hearing on 8694. The basis for the petition or revocation there is the new arrest in the 10989 matter that we just discussed.
Will you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? What is your name?
I'm sorry, can you pull that mic? Word you.
Now
Rodriguez.
the last person you're like, can you pull that mic? Court reporter, what is your problem?
How old are you?
47.
Do you understand English?
Yes, I do, Your Honor.
On October 3rd, the state of Indiana filed a petition to revoke your probation. The allegations in that are that you were charged with a new crime of possession of methamphetamine under cause number 64 D01 2510 F6 10989, which has now been transferred to this court. So in the petition to revoke, Ms. Madrigal-Otano is recommending that I sentence you to your suspended sentence, which is 363 days for violating the terms of your probation on the old case. In a petition to revoke, well, do you understand what the allegations are in the petition to revoke your probation?
Not completely.
Okay, here's what it is completely. What it is completely is I sentenced you in May. One of your terms of your probation was to not get rearrested. And I then placed you on probation.
I love math.
At your sentencing in May. It's now alleged that you've been rearrested for violating a law, and that based upon the violation of that law, that you should end up serving your suspended sentence based upon the violation of the law in the new case, if that's proven. In addition to
I
then
hate
being
grammar.
sentenced on the new case.
And geography.
Do you understand all that now?
Yes.
All right.
Sorry, I didn't need to.
That's all right. It's complicated unless you do it every day. In a petition to revoke, you have rights. Your rights differ, though, than in a normal criminal case. You're entitled to a hearing in front of me, not entitled to a jury trial. Do you understand that? At that hearing, the state must prove the allegations against you by the preponderance of the evidence, which means the greater weight. Do you understand that?
Can you repeat that last?
Sure. It's like if you take the scales of justice and they get tipped a little bit one way or the other, that's the greater weight. Do you understand that in a revocation matter, the state only has to prove the allegations by the greater weight of the evidence, not beyond a reasonable doubt? Do you understand that? All right. So here's exactly what it is.
Here's
So
exactly what
on
it
May,
is. Before we find out what he did in May, does Victoria go to any lives at night? I miss Victoria. So, does anybody ever see Victoria out in the wild? Because I want to see Victoria in a chat room. Because I miss Victoria. So if anybody knows of any lives Vicky hits, let me know.
May 25th or May 20th of 2025, you pled guilty in this court and I placed you on probation. One of the terms of your probation was you not be charged with a new crime or not commit criminal acts. On
Thank you, Hanky Panky. So she changed her name to
October
Kathy.
1st,
She changed her name to Kathy with a C. But then I think she changed it back. Anyway, you would know if you saw her.
the state of Indiana filed new charges against you. And one of those, those crimes allegedly occurred on September 26, 2025, while you were on probation in this court.
Welcome back, Hanky
And it's
Panky.
alleged that you possessed methamphetamine and possessed marijuana
Hanky Panky's been here for a while.
in violation of Indiana law. That's the new charge. If you're found guilty of violating the new charge, then that could violate you in the case that you're on probation. And you could be sentenced at that point for the suspended sentence as well as the new charge. Do you understand all that now? All right.
That's a question.
Yep.
I have the sets of papers that I received. Did I find different that in the papers I walked out of Porter County Jail with, it says one thing, doesn't mention no method.
It says what? You need to speak a little louder.
It says it's a sworn statement of the officer, and these two papers differ. There's charges on this one that there ain't on this.
Go ahead and hand it to him.
Other people that walked out of jail, and this is what I received. And on what I walked out of jail with only mentions marijuana. It doesn't say nothing about no methamphetamine.
No,
And that's a
we're
sworn
closed
statement of
today.
Officer Hart.
Yeah, charges all the time, dude. It's fine. I do work today, though, T. My new motor came in for my dryer. So now I'm going to dismantle a dryer and replace a motor. The new motor is perfect. It came with a new pulley, so I don't have to reuse the old pulley and the belt and no. I'm good. I got a brand new pulley with a brand new motor. And you know, old pulleys love to seize. So now I don't even have to worry about my belt breaking for years, because my pulley is not going to seize. It's just not. It's brand new, right? Oh, heck yes. There's a nap is in my future. This coffee ain't going to stop that. Here's my plan. Here's my plan. This is what people dream of, and I get to do it. Inside my dryer is this big drum, right? I'm going to take that drum right out to my backyard, and I'm going to clean the heck out of that drum. I'm going to scrub that drum down. Yes, I am. So tomorrow I'm going to have a sparkling clean dryer drum, and everything in there is going to be nice and vacuumed, and it's going to work. It's going to actually do something. When I press the button, it's going to do something. Yeah, so I do work today, but I don't get paid for it. actually do get paid for it, because when a motor breaks in a dryer, most people just go buy a new dryer, because that's the smart thing to do. Is to go buy a new dryer. No, not me. Not me. I'm going to do it myself and save all that money, and then that's like getting paid for today.
I'm kind of asking us.
All right, so about the bottom of the page of the documents that you gave me, there's a box that says possession of methamphetamine. So the papers that you gave me show that you allegedly possessed methamphetamine. That's the allegation in the new case. Do you understand all that?
I just didn't see the position of methamphetamine.
Well, it's there. All right, so,
I was, like I said, I was more asking him.
all right, let me, before you ask any more questions, let me advise one of your rights is to remain silent, okay? In the petition to revoke your probation, you have certain rights. You're entitled to a hearing in front of me. Do you understand that? At that,
Oh, I'll call Monica's husband if I have to. Don't worry. But I just don't think I have to, because we're not rebuilding the motor. I'm just replacing it. You know what I mean? Pop the old one out, pop the new one in. I'm going to have my camera ready, take pictures of every single thing before I touch it. That way I know that I can put it back in the exact same way and clean it. I know. Don't get the belt wet. I already know. I'm fine. It was mostly the inside I really wanted to get clean, not the outside. But I'm gonna be on Discord. Help! I'm gonna be on Discord screaming help to two people. The husband and Nan, to stop the bleeding. I only have 9 fingers.
hearing, the state must prove the allegations by the preponderance. Do you understand that? You still have the right to face and cross-examine every witness, whoever would be that would testify at that hearing. Do you understand that?
Yes.
You have the right to have me issue subpoenas to have witnesses testify for you. Do you understand that?
Yes, sir.
You have the right to remain silent. You can't be forced to testify against yourself. Do you understand that? And you have the right to an attorney in the revocation matter. Do you understand that? If you cannot afford an attorney, I will appoint one for you. Do you understand that?
Yes, sir.
In this case, the allegation in the revocation matter is that the state of Indiana filed a petition to revoke your probation because you were charged with a new crime, which we're going to address in a second. So do you admit or deny that you were charged with a new crime?
To jail.
All right, but you can say you deny the new charges. All right. All right, now we're going to shift gears. I'll enter a denial on your behalf. In cause number 2510 F6-10989, you saw Judge Matty, I believe, on early October.
My notes show.
October 2nd.
Yes.
And at that hearing, Judge Matty ordered the new case to be transferred to me. And that new case is one in which you allegedly possessed methamphetamine and down at the bottom of the page, those checkboxes that you allegedly possessed methamphetamine, and that you possessed marijuana, and that was at 11:52 a.m. on September 26, 2025, at 101 East Chicago Street.
Wow, that was fast. They already got him. This is his second hearing in front of a judge, and this just happened in September. They're really mad at him.
And all you saw, when you saw Judge Matzi, all he did was advise you of the charges and the penalties and then transferred it to me and set bond for you. Is that right?
Pretty much, yes, I should have been released the day prior, but something happened with the order.
That you have to.
I'm sorry, they had told me I should have been released on Wednesday, the day prior, but something happened when the judge signed the order. Nobody took me out.
All right. So, do you have the money to hire a lawyer to represent you in both cases?
You know what, Your Honor? Honestly, I work right across the street at a restaurant, and our hours have gone down. So,
Do you have the money? Do you want me to appoint a public defender?
if you could, please.
Jasmine would be a great public defender.
I am appointing Attorney Mitch Peters to be your public defender. You are ordered to appear on the following dates: January 5th at 9:00 for an omnibus hearing, February 2nd at 9:00 for a final pretrial conference, and March 30th at 1:00 for jury selection. Mitch Peters is now your public defender. The probation revocation matters will also be set for a status on January 5th at 9:00. Having said that, you are still on probation now. You aren't to violate any laws. You're not to test positive for any drugs, and you're to see Ms. Madrigal-Otano occasionally. Is that right, Ms. Madrigal-Otano?
Judge, he's on administrative probation, but I'll be checking in every once in a while.
All right.
Again, of course I'm going to try this one. Of course I am. Miss Madrigal-Otano. Miss Madrigal-Otano? Is that what he said? I said yes, of course I'm going to try this one, and then I forgot her name because I said words. Miss Madrigal-Otano?
So I will call Mitch Peters. I will see you January 5th at 9:00, sir. Thank you. We will be in recess for about 5 minutes once again.
No, sir. Incorrect. You're done here. I'm done. I'm done with you. I was expecting you to be you, and you just were every other judge today. I'm still getting more of Claymore. He's great. He's so good when he's mad. Oh, man. All right. If you guys could pick between Colorado, New Jersey, Indiana, Texas, Georgia. Just so you know, if Wisconsin comes on, I don't care what you pick. If that judge from Wisconsin comes on, I'm getting him first. I check him every day. He's like an, I don't know, obsession. He's never on. Anyway, what would you prefer to see? What do we enjoy the most? Uh-oh. Is it on my phone? Yeah, I think it's on my phone. No. Georgia, Texas, Georgia. Yeah, Wisconsin would be good. I just never even attempted that. Jeez Louise. I'm looking at something, guys. Oh yeah, I used to do Hawaii courts. That's right. This is Hawaii courts. It's not good. It's just not good. I'm going to show you real quick. Not great. All right, give me 1 second to resize. Yeah, it's good enough for now. That's good enough. We're just looking. We're peeking. real quick. I love how they start, if they start the right way. I love how they start. I love it. This is an hour and 13 minutes long, so we are not going to listen to this. No, there's no sound yet. Alaska stopped streaming. I used to play Alaska clips, remember? I didn't hear that. Hold on. Remember when I used to play Alaska clips? The audio was terrible. The video was worse. I want to hear them start.
Ahea o ko e ko ka aha. Inahe kuliana imua o kia aha ho kolo kolo ki e ke hano hano o ko moko aina o Hawaii. Inai mai, elio mai, ilohi ia kaleo. Hear ye, hear ye, hear ye, all persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalo, please be seated.
Hawaii.
Understood the gravity of what this was. I mean, this was a law basically.
You didn't want to contravene the statutory language. That's the sense I got when I was reading the record.
Correct. And I think
of the version of the statute it actually adopted in 2016, which requires.
Okay, we'll do this one tomorrow. We're gonna play this tomorrow. It's the Supreme Court said it's no verdict. They're still thinking about it. This was a year ago. I might be able to find the verdict on this one, but yeah, the accent did it. I'm gonna save this, and this is what we're gonna do tomorrow. It's fine. It's fine. We'll just chat if it's boring. We'll just talk and chat if it's boring. I can't wait for tomorrow, guys. Alright. Thank you for coming out. I'm going to set up OJ. And then I shall see you all again soon. Bye, guys. Thank you so much. Thank you. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcoming place. I can count on distraction from my pain. 'Cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.